Mr. Craig?
Thank you, Your Honor. May it please the court, counsel. I'm here today on behalf of the plaintiff in this lawsuit, Cheryl Albaugh. Ms. Albaugh is the daughter of and has power of attorney for her mother, Shirley Vumard. Ms. Vumard is a former resident at the Reserve on Walnut Creek. She lived in apartment 232 at the Reserve beginning in 2007 until 2014, at which point she had developed dementia that had progressed to the point where she could no longer live independently and had to move out of the Reserve because they don't provide that assisted care type of service, and so she had to move into assisted care facility. Despite vacating the apartment, the Reserve continued to charge her a monthly rent charge, and they refused to refund a $128,000 entrance fee and supplemental amount that she had paid when she had moved into the Reserve. Eventually, when Ms. Vumard quit paying that monthly charge after she had vacated, the Reserve purportedly forfeited that $128,000 entrance fee and supplemental amount. We filed a multi-count petition against the Reserve. We did also move for summary judgment on one claim, that was the landlord-tenant claim. The Reserve then cross-moved for summary judgment on all the claims. The district court denied our motion for summary judgment and granted the Reserve's motion for summary judgment in full, dismissing all of the claims without a trial. That's a lot of ground to cover here in my short time I have, so I'm going to focus my arguments on the landlord-tenant claim, because that was the subject of both of our motions and probably the most complicated issue. So the starting threshold question as far as applicability of the Landlord-Tenant Act is whether there's a rental agreement. The Act applies to rental agreements entered into parties after January 1st, 1979. And the Landlord-Tenant Act defines a rental agreement broadly as any oral or written agreement embodying the terms and conditions for the use and occupancy of a dwelling unit. And if you look at the application agreement and the covenants of occupancy that go along with it, you'll see everything you'd expect to see in a rental agreement. You see it gave Ms. Vumard the sole and exclusive right to occupy apartment 232 at the Reserve, provided for monthly rent charges, it provided for payment of utilities, it had a term of occupancy, sort of had everything you'd expect to see in a lease. And in fact, the agreement itself specifically said that a landlord-tenant relationship is created by this agreement. And the Reserve in the district court and in its briefing on appeal haven't challenged that particular point. So I believe it's conceded that this is, in fact, a rental agreement under the Act. So the starting point of the analysis is that the Landlord-Tenant Act applies because this is a rental agreement. And so unless there's some other good reason that the Act shouldn't apply, it does apply. Now, the district court held in its summary judgment ruling that it found that the legislature's intent was to regulate two different types of housing arrangements. A senior congregate adult living facility under 523D and rental agreements under 562A, and that those types of facilities stand separate and apart was the language it used. The district court erred in finding that because one, the Landlord-Tenant Act has express exclusions in the statute, and the Reserve does not fall within any of those exclusions. And two, there's no conflict between the landlord-tenant statute.
Let me take you up on the conflict issue, Mr. Craig. As I read 523D, first of all, you can clearly have an entrance fee that exceeds 6 months of residency, correct? Which is far greater than you could do for a security deposit, right?
That's correct, Your Honor.
And then if you go to 523D6, it contemplates that the entrance fee could be in whole or in part refundable, right?
Correct.
And if those things are true, an entrance fee that's refundable in whole or in part is a security deposit under the Landlord-Tenant Act. It'd be per se illegal if it's for 6 months or more, right?
No, I don't agree with that because a security deposit is any deposit of money which is used to secure performance of the rental agreement. And you could have an entrance fee that isn't being used as a security deposit, regardless of whether it's refundable.
Give me an example.
Well, if you have an entrance fee that's not refundable,
I've just pointed out that that 523D contemplates refundable security deposits, right?
Well, you could have a refundable security deposit that was not subject to forfeiture based on default by the resident. What the problem here is the reserve merged the concept of an entrance fee and a rental deposit. They provided for it to be paid up front. They provided that if that the resident could get it back at the end of the term of the agreement, and they provided that if the resident defaults in any of their obligations under the rental agreement, then their right, title, and interest in that entrance fee is forfeited and becomes the sole and separate property of the reserve. And that fits the definition of a rental deposit, which is a deposit of money to secure performance of the rental agreement. And so it's not a conflict in the statute itself, it's the way they structured their entrance fee, because nothing in 523D requires an entrance fee to be refunded. Nothing in 523D requires that the entrance fee be used to secure performance. That's simply how the reserve structured their entrance fee, and that turned it into an illegal deposit in this case.
What is entrance fee used for?
What is an entrance fee?
What would be a lawful use of the entrance fee?
I don't think the statute requires any particular use of the entrance fee. It defines entrance fee as a payment of money by the resident to the facility for acceptance into the facility. And that's the extent of the definition.
Entrance fee seems to be like a seat license in these football stadiums. You pay X amount of dollars and it gives you the right to buy the seats. An entrance fee seems to be you pay X amount of dollars, then you have a right to lease or lease a premises at the property. Is that a good analogy?
I think that is, yeah. It's your acceptance into the facility. So there is no conflict in the statute, and the district court erred because it violated what is a fundamental rule of statutory interpretation, which is when you have two statutes that apply, you give them both effect and you harmonize the statutes. You don't look for ways to find that they don't apply. And that is true if they're, whether you're talking about a general statute and a specific statute. If they can both apply and can be harmonized, you let them both apply. And again, there's no conflict here. The two statutes cover different subject matters.
Do you really get your entrance fee back here if you comply with all the obligations of the lease?
The contract says there's no guarantee that you get it back.
Don't you really get it back by finding someone else to take your place and paying an entrance fee?
That's how the reserve has structured their entrance fee, yes.
So they're not paying anything back.
Well, if you look at the application agreement itself, the resident pays the money to the reserve, and the agreement specifically states that it's, you know, we agree to pay the entrance fee in supplemental amount upon signing the agreement, and then the sum is deposited in an interest-bearing escrow account. That's what the agreement says. And then the practical effect, the practical way it worked is that if someone transfers their membership, they get a check from the reserve. So their money is going to the reserve, and if they move back,
That's contingent on the new member paying an entrance fee, isn't it?
that's how the reserve has structured their entrance fee. And I would submit that that doesn't make it not a rental deposit. If you were looking at a conventional landlord-tenant situation where you have an apartment complex and the rent is $250 per month and the rental deposit is $500 per month, that landlord could write into the lease that one, that if you default in any of your obligations under the rental agreement, you're gonna forfeit that rental deposit. And they could also write into the contract that we're not gonna give that rental deposit back to you unless you find a new tenant to basically take over and pay that rental deposit back to you. That doesn't make it not a rental deposit, that just makes it an illegal deposit under the landlord-tenant statute. The district court also erred in finding that that senior adult congregate living facilities under 523D stand separate and apart from rental agreements. That was the language of the decision. If you look at the definition of a provider of senior adult congregate housing under 523D, it specifically defines that provider as someone undertaking to provide that housing through a lease or other type of arrangement. So the definition of a provider under 523D specifically contemplates that the contractual arrangement between the two parties could be in the form of a rental agreement. The district court did correctly find that the reserve doesn't fall within any of the exclusions, express exclusions contained in the Landlord-Tenant Act. So it has a list of different types of housing arrangements that are not subject to the Landlord-Tenant Act, and the only one that potentially could apply to the reserve is an exclusion for housing.
Why would the legislature have two separate acts cover, because according to your argument, all 523Ds are covered by the Landlord-Tenant Act, it sounds like to me.
Well, I don't know if that's necessarily true. I mean, I think it would depend on the facts and circumstances of each facility. 523D regulates senior congregate adult living facilities as well as continuing care facilities. You could have a continuing care facility that would fall within the geriatric exception and thus be excluded from the Landlord-Tenant Act. But the legislature
Why
all
would
the
the
time,
legislature want two acts to cover the same facility?
because they cover different ground, frankly. The 523D is primarily a disclosure statute, which says that these facilities have to provide certain information to residents before they invest their entrance fee into the resident. The Landlord-Tenant Act is much broader in scope than that. It governs the overall relationship between the landlord and tenant and provides different requirements. And so they don't cover the same ground. And the legislature does that all the time. They enact different statutes that apply. And when we interpret statutes, that's the starting point, is that the multiple statutes apply unless there's an irreconcilable conflict between the two statutes. And there is no conflict here. So there's no reason why they both can't apply. The district court also erred because Chapter 523D actually contains an express savings clause. So the law is that generally for one statute to be deemed to displace another statute or preclude application of that other statute, legislative intent to do so has to be clear. Here, 523D expresses the exact opposite intent. It includes a savings clause that says that application of Chapter 523D doesn't limit any other liability that may exist by virtue of any other statute. On the flip side, you have the landlord-tenant statute that mandates broad coverage. It says it should be liberally construed to promote its purposes. So nothing in those two enactments suggests that one precludes the other. That savings clause says that the landlord-tenant statute applies. It says that in determining whether the landlord-tenant or any other statute applies, basically ignore 523D. Yet the district court found that 523D somehow overrides the landlord-tenant statute, and that was error. The district court also found it important or noteworthy that Chapter 231C, which governs assisted care facilities, and Chapter 231B, which govern elder group homes, those two particular arrangements have specific provisions in them that make them subject to the Landlord-Tenant Act. And the court found that to suggest a legislative intent that...
That seems to cut against you, that the legislature knows how to place these more specialized living arrangements within the Landlord-Tenant Act when it chooses, as it did in those two you just mentioned, but it didn't in the one we're fighting about. So didn't Judge Huppert, in making that point, I mean, isn't that contrary to your current argument?
And my response to that would be twofold. One, a senior adult congregate living facility such as the Reserve doesn't fall within that exclusion for residents incidental to the provision of geriatric services. And the district court found that. It didn't fall within that express exclusion. And so the Reserve is not taken out of the statute by operation of that exclusion. So there's no need to insert a provision in the act bringing them back in because they were never excluded in the first place. And the other answer to that question is that there's a savings clause in 523D that you don't find in the other two statutes, which says when considering application of other statutes, basically ignore 523D. And so you just look at the landlord-tenant statute, and by its terms, does it apply? And in this case, it does, because it's a rental agreement and it doesn't fall within one of the express exclusions contained in the statute. And I think I'm out of time for the
Oh,
moment.
for some reason, your yellow light didn't go on, so why don't you take a minute to sum up and.
Thank you, Your Honor. So for that reason, the district court erred in granting summary judgment to the reserve on the landlord-tenant claims and refusing to grant our own motion for summary judgment on our claims. We had asked for some affirmative relief on those claims. I'll point out that the reserve, neither in the district court nor in its briefing here, addressed any of those substantive aspects of our own motion for summary judgment. So we're asking that the court not only reverse the district court, but order it remanded with instructions to grant our motion for summary judgment. Thank you.
Thank you, Mr. Craig. Mr. Miller?
Thank you, Justice Wiggins, and may it please the court. Ms. Colby, Mr. Craig. I'm here on behalf today of the Reserve and the dozens of members who haven't sued the Reserve, who are trying to enjoy the senior living years that they've planned to enjoy their entire lives under an arrangement they agreed to, just as Ms. Vomar did. There was no basis for trial in this case because Judge Huppert found correctly, as a matter of law, there was no basis to disrupt the contractual relationship that Ms. Vomar entered into. Iowa law isn't a device for next generation to take a look at an agreement that their parent entered into and try to erase it or go back in time. In fact, the agreement that was in place here was appropriate for various reasons I'll discuss with you today, and we ask that this court affirm the district court's ruling dismissing the case.
I mean, kind of the core of the matter, and I think Mr. Craig summed it up very well from several different angles, is you know, why doesn't the Landlord-Tenant Act apply here when this is a rental agreement for all intents and purposes, and we can't find a provision of law anywhere saying that the Landlord-Tenant Act doesn't apply?
Yep. Well, thank you, Your Honor. I appreciate that question, and that is the crux of the matter. There are some other issues presented too that I'd like to get to because I know I won't be back up here with you. I don't agree with Mr. Craig this is a complicated case, and I don't concede it's necessarily a Landlord-Tenant Act agreement. I believe he said that, and I'm not quite sure where he's coming from on that. The fact of the matter is, and your questions have put the finger on many of these concerns, but 523D and 562A simply don't setting them aside or against each other don't work and are not consistent with each other. And the most specific example of that arises from this entrance fee concept, which it indicates it has to be a $5,000 amount or more, could be a 6-month duration. It's nothing like a rental deposit, and it's not a Landlord-Tenant Act situation.
If you treat the entrance fee as a rental deposit, where it's refundable, et cetera, and I'm not gonna go everything Mr. Craig talked, why isn't it subject to the Landlord-Tenant Act?
Yeah. Well, Your Honor, I respectfully disagree with Mr. Craig's characterization of what this entrance fee amount, or the entrance fee is. The entrance fee, there's mentioned before about the language with an escrow and things like that. We're overlooking a lot of terminology and other language in the agreement that indicates this is not a situation where money is being paid to the reserve as if it was the landlord, being held onto by the reserve and not returned. The escrow, for instance, was for the first generation that came in. This facility, the reserve, was built via raising funds through entrance fees and supplemental amounts. And then if you look at the application agreement and the system that's set up in there, we didn't talk about any of the bolded terms that are in the appendix at page 28 to 29 and elsewhere in briefs and the like. But the system that's specifically set up is you will come in if you're the first generation. Your option to get out is to transfer your unit via somebody else coming in and taking the entrance fee. So it's a mischaracterization to say that the reserve is holding on to these amounts as a rental deposit.
Is that the only difference? Because you get your money when you leave if you find someone else to take it? What is the difference between a a deposit under the Landlord-Tenant Act and your entrance fee?
Well, critically, the deposit concept denotes 2 months. The idea is not necessarily refundable. Here we have refundable possibility. It's just the amount and the usage are not equivalent to the rental deposit.
That could make it an illegal security deposit. I mean, the question becomes not the amount, but the way it's used and the character and the way your entity uses it. How is it used differently than a real security deposit?
Thank you, Your Honor. I think it doesn't meet the rental deposit amount or definition, and it's permissible because 523D makes it permissible. It specifically describes what an entrance fee is, contemplates the creation of the senior congregate living facility that would be used by taking in entrance fees that creates this.
I understand that you can do it and you can do lots of things under 523D, but factually, how was your entrance fee different in character than a security deposit, the way you guys use it?
I guess, Your Honor, I would start by saying you guys, the Reserve, do not use it in the same way as a rental deposit.
And that's what I want to know. How
Yes.
did they not use it in the same way?
Yeah, from the outset, the entrance fees were used to create the building. It was brought in to create the senior adult congregate facility known as the Reserve. And then now, subsequent to that, the Reserve does not hold on to entrance fees. Entrance fees are paid on member to member over time. And there's a forfeiture aspect of it if there's a person that doesn't pay, but then in fact, what is being forfeited is the right to get the entrance fee back under the hypothetical refund.
Mr. Craig says it isn't paid member to member. It's the new member pays into the Reserve, and then the Reserve pays the new member. I mean, has he mischaracterized that?
Unfortunately, I believe he is. I know he is, I'm sorry. But the fact of the matter is that these transactions, yes, the Reserve's, is basically, I don't want to use escrow agent, but that's a sort of a colloquial way to describe it. If one member, if Ms. Vamard reached a point where she was ready to transfer her unit and member X was going to come in, member X would have paid the negotiated amount that Ms. Vamard or her family agreed to, and then that money would have been held for the Reserve and turned back over to the Vamard as she went out, and the new member would take over the occupancy of the unit. I think it's also important with respect to the difference between 523D and 562A, that 523D, above and beyond the membership or the entrance fee aspect, also includes other aspects of contractual provisions in the relationship. There's governance of what this type of situation will look like, specifically calls out that senior congregate adult living facility like the Reserve would include the availability of services, which there's no dispute that the Reserve does offer, and also contemplates ongoing supervision, and there's some quarrel as to how much supervision, but certainly oversight by the insurance division, which remains engaged. So back to
Counsel, how would what would be the practical effect going forward for these living arrangements if we reversed and entered summary judgment in the plaintiff's favor?
Thank you, Your Honor. Obviously, we would go back and have a trial on these issues. It seems, well, I think to your point, if we're looking specifically at Landlord-Tenant Act, yes, I think the fact of the matter is there is not a large argument about the plaintiff's claims that, hey, look, if you look at this, it's unconscionable because your entrance fee is the equivalent of a unconscionable rental deposit, because if that were the case, it would be critical and end this industry in this type of matter. I mean, I think that is a factor that must be considered by the court, that this needs to be squared with the overall picture of senior living options, and the idea the Landlord-Tenant Act would apply would be fatal.
Mr. Miller, I mean, I'm still coming back to here's my issue. I have no doubt, or very little doubt, that if I could pick up the phone and call the legislators that passed 523D in 1989 and ask them what they intended, I think they intended a separate regime that was not subject to the pre-existing Landlord-Tenant Act. But they never said that. And so what are we supposed to do? Because normally we follow what the legislature said, not necessarily what they intended, right?
Well, I do appreciate that comment, Your Honor, but I think they have said it by their silence. If you look at 231B, 231C, other senior living options, they've looked at those statutes over the past few years, and they specifically called out and applied 562A. I think that the fact of the matter is it wasn't intended to apply. Perhaps, you know, I'm certain in 20 other cases you've had in this session, there may have been circumstances where we wish the legislature would have said something differently or more clearly. But I think clearly from the overall setup of what we're looking at here, the specific carve out of what 523D facilities are compared to what 562A implies, you can draw from that the legislature intended that this is something different. And then again, they've also had an opportunity to look through these statutes over the past few years and made no further comment or change.
Is this a good case to apply the canon of construction that if you have a conflict between two statutes, a general and a more specific one, the more specific one should control?
I do believe that's correct, Your Honor, and I believe Justice Huppert did note that and rely on that principle in part, that we are looking and drilling down into a very specific type again. I just think to the question earlier, I think is putting, Justice Wiggins put his finger right on it. How can these two coexist? And I don't believe they can. You must look at 523D as prominent. If I may, I have a few more minutes. I'd like to just touch on some of the other issues that Judge Huppert ruled in our favor on. And those issues launch from, again, the bold languages of this agreement. And again, I commend to you, please do read it. I'd like to paraphrase a few of the statements that are pretty close quotations. But Ms. Vimard signed an agreement in bold, that it said in bold at the end of the agreement that the reserve will have no further obligation to refund or return any money to her, that her ability to recover her entrance fee and supplemental amount that was paid to the member or that she paid in would depend entirely on her ability to transfer to a new member who would pay that money back out or whatever the money would be that they would agree upon. And finally, and perhaps foremost, there was no guarantee that she would recover the entire entrance fee or supplemental amount at the time of transfer. Another important critical set of facts that Mr. Craig didn't really touch on specifically was the circumstances that led Ms. Vimard to move into the reserve. She left a home on the south side of Des Moines based on a concern that we had the opportunity to speak with her daughter and son-in-law. Neighborhood's changing around her, she's getting older, some safety concerns. Her son-in-law's mother was already at the reserve from all intents and purposes and indications, happy there with what she was doing and living. And so the reserve became an option for Ms. Vimard, and she decided to move in after reviewing the application agreement. We confirmed, and there's evidence in the record, that she certainly either had the opportunity or did speak with an attorney or financial advisor, certainly had her children advising her as well. So those type of circumstances tie back into the arguments that we were faced with, that the reserve, albeit a creature of Chapter 523D, somehow that there's a consumer fraud aspect here, that she was misled about the circumstances. As Judge Huppert properly noted, this was an integrated agreement. The ideas about the fraud, there was no indication that there was some unspoken plan that the reserve planned to go forward. The evidence was bare with respect to the consumer fraud theory. Furthermore, the key there was the statute of limitations that ran from 2 years from when the agreement was entered into.
Rather than the statute of limitations, on the merits of the consumer fraud, am I correct in understanding that the way the reserve decided how to price the entrance fees on the house units, the ones that were owned by the reserve, which I guess is her complaint that they were undercutting her ability to resell her unit because of how they were, that's done by by kind of a board of directors that's elected by all the members that are there. Is that correct?
Your Honor, I'll answer your question right away, but I do want to note with respect to this claim, I do ask that the court pay close attention to what the record is in this case specifically surrounding what the theories were of plaintiff. That being said, yes, there's a board of directors that's responsible for the kind of governance and the day-to-day operation, hiring a
And
manager.
who elects them?
The members, yes, the members. They elect them. There were also arguments, of course, with respect to unconscionability, and I, with my time running out, I think we're going to finish there. Of course, as you know, there's procedural and substantive unconscionability. Procedural basically being the sharp practices type circumstance. Certainly, even though Ms. Vomard was 60 or older, I'm not precisely sure how old she was at the time she entered this agreement, there were no sharp practices. She read the agreement, had the opportunity to consult with people. This was an arm's length transaction, and had an agreement with bold terms. With respect to the substantive unconscionability and the idea that nobody in their right mind would take this agreement, well, I'm sorry, Your Honor, there was many people that would take this agreement. Your Justices, we already had, I'm sorry, I see my time is up. May I just finish up real briefly, Your Honor?
Why don't you take a minute to sum up?
Okay, thank you. So certainly there were other people, including Ms. Vomard's in-law across the way that was already in the facility. But in sum, Judge Huppert got it right. He considered the issues and the record before him in this case, properly entered summary judgment with respect to 523D, 562A, and from there, all the issues flowing, including unconscionability and the like, and we ask that you affirm his ruling. Thank you.
Thank you, Mr. Miller. Is there any rebuttal?
Yes, Your Honor.
Mr. Craig?
Thank you, Your Honor. I just wanted to address a discussion that Mr. Miller had with the court about mischaracterization of the record, and I think it was in response to Justice Wiggins' question about whether this was really a member-to-member transaction involving the entrance fee or whether it was between the member and the reserve. And if you look at page 91 of the appendix, that's the application agreement, it specifically says, unless otherwise agreed to in writing, the resident agrees to, upon signing the agreement, pay the entrance fee and supplemental amount, which sum shall be deposited in an interest-bearing escrow account in a depository institution. So Ms. Vomard and other residents that sign this application agreement are paying the entrance fee to the facility. And then if you look at page 155 of the appendix, it's a reserve document. It's a procedure manual talking about transferring your unit, and it says in that process that the proceeds from the entrance fee and supplemental fee will be paid by check from the reserve within 10 to 15 business days following the closing of a new member coming on. So it is a payment that's made to the facility and a payment that the resident gets back from the facility. Now the reserve has structured this fee in such a way that a resident trying to get out only gets that money back if they find a new resident to take over. But again, I'll go back to my argument, that doesn't make it not a rental deposit. It just means they've structured their rental deposit in a way that violates the Landlord-Tenant Act. The Landlord-Tenant statute, as I've discussed, does contain express exclusions, none of which apply to the reserve. And when the legislature enacts a statute and has express exclusions in that statute, the presumption is that no other exclusions are intended. Despite that fact, the district court here found an exclusion, an implied exclusion for 523D facilities, even though 523D specifically says, hey, this statute doesn't limit a liability which may exist by virtue of other statutes. So the district court erred in interpreting the statutes in that way.
Would you mind addressing briefly your claims that the reserve undercut your client's ability to transfer? You know, you've alleged, I think, a breach of a duty of good faith. The briefing shows that's not it's not an independent kind of claim. I mean, you've got to point to a contractual provision that's been undercut, if you will, by an opposing party. Suggestion, you heard it, was that there was an independent board and so forth. But help me understand the pip of your claim there.
Would that be on the implied covenant claim?
Yes.
Because those facts kind of support several claims. There's a fiduciary duty claim.
Yeah.
a consumer fraud claim and breach of implied covenant. Yes, on the implied covenant claim, the district court held there was no express term in the contract to sort of attach that claim to. Now, we recognize that the implied covenant does not create new substantive terms. Rather, what the implied covenant does is it protects the party's justified expectations of what's going to happen under the contract. And it prevents one party from taking actions that defeats those justified expectations. We believe the district court erred in holding that there were no express terms that implied duty could attach to.
Help me with the facts that support that.
Sure.
I appreciate your general description of the legal environment.
Okay, so under the agreement, she was required to pay a $128,000 entrance fee and supplemental amount. If you look at the covenants of occupancy and the disclosure statement she received, there's a schedule of entrance fees and supplemental amounts that are required for each type of unit at the reserve, including the one Ms. Vumard ended up moving into. There's provisions in the agreement that require or provide for Ms. Vumard to get her money back when a new tenant comes in. And there's also an agency agreement that Ms. Vumard signed that's part of the record here to engage the efforts of the reserve to transfer her membership. A jury could find, based on those express contract terms, that Ms. Vumard had a justified expectation that future residents would be required to pay entrance fees and be required to pay entrance fees in the amounts that were included in the disclosure statement and the covenants of occupancy, and that the reserve would not take actions that would sort of undercut her ability to transfer her unit. And the facts that we have in the record are that in 2015, the reserve had acquired some memberships or had some empty apartments, and so they reduced entrance fees all the way down to $5,000 to try and move these apartments. And that's the statutory minimum entrance fee when my client paid $128,000 and other residents like her paid six-figure entrance fees. They reduced the entrance fee to $5,000, and then they took it one step further in 2015 and they opened the facility up to leasing, so people can lease these same units without any entrance fee payment whatsoever. And a jury can conclude that that seriously undermined the value of my membership. And I think I'm out of time. Can I just
Go ahead and finish.
Okay. That a jury could use, its own logic to infer that when I'm trying to transfer my membership for $128,000 and the unit down the hall, the same unit, can be leased without any entrance fee whatsoever, that undermines the value of my investment, contrary to my justified expectations as a resident. Thank you, Your Honor.
Thank you, Mr. Craig. We'll now consider the case of Albaugh versus the Reserve submitted, and you may adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.